Are you familiar with Judge Lamberth and Judge Hogan?
I don't know either of them. I know who they are.
Fair enough. They're D.C. Judges, federal district court judges who are hearing habeas appeals from Git Moe detainees. And I'll provide you some of the comments they made. It is unfortunate, according to Judge Hogan, it is unfortunate in my view that the legislative branch of the government and the executive branch have not moved more strongly to provide uniform, clear rules and laws for handling these cases. And I've got other quotes that I will provide you. What I'm trying to do here is lay the foundation for the idea that our laws that exist today do not recognize the dilemma the country faces. The administration has determined that 48 people held at Git Moe are too dangerous to let go, but are not going to be subject to normal criminal proceedings. In other words, we believe the evidence suggests they're members of Al-Qaeda. They've all gone before a habeas judge and the judge agreed, but they're never going to be tried in a traditional fashion. Is the administration's decision, in your opinion, consistent with the power under the law of war to do that?
Well, as Solicitor General, Senator Graham, I have argued the position that
and I think
this is fully legal.
Very well, you have argued for the proposition that this president and all future presidents has the ability to detain an enemy combatant with sufficient process if the executive branch believes that they're dangerous and not require them to go through a normal criminal trial. And what we have to do is find out what that process would be, this hybrid system. You argued against expanding habeas rights to Bagram detainees held in Afghanistan. Is that correct?
I did, Senator Graham.
As a matter of fact, you won.
In the DC circuit.
And you probably won't be able to hear that case if it comes to the Supreme Court, will you?
Well, that's correct. And the reason.
Well, that's good because we can talk openly about it.
I mean, if I could just say, in general, the Solicitor General only signs her name to briefs in the Supreme Court, authorizes appeal, but does not sign appellate briefs. But I determined that I should be the counsel of record on that brief because I thought that the United States interests were so strong in that case based on what the Department of Defense told our office.
Well, I want every conservative legal scholar and commentator to know that you did an excellent job, in my view, of representing the United States when it came to that case. And you said previously that the first person you have to convince when you submit a brief or take a case on is yourself. Is that correct?
Well, I said that in reference to the cases that I argued specifically. Of course, when I write briefs, I write from, or when I sign briefs, when I'm counsel of record on briefs, I'm taking the position of the United States, that I'm representing the position that I believe and that our office believes is most consistent with the long-term interests of the United States government.
Have you convinced yourself, as well as representing the United States government, it would be a disaster for the war effort if federal judges could intervene and require the release of people in detention in Afghanistan under military control?
Senator Graham, I chose to put my name on that brief, as I said, which is a very, very rare thing in the appellate courts, because I believe that there were very significant United States...
Let me read a quote. The federal court should not become the vehicle by which the executive is forced to choose between two intolerable options, submitting to intrusive and harmful discovery or releasing a dangerous detainee. Do you stand by that statement?
Senator Graham, can I ask whether that statement comes from that brief?
Yes, it does.
I mean, that statement is my best understanding of the very significant interests of the United States government in that case, which we tried forcefully to present to the court. And as you said before, the D.C. Circuit, a very mixed panel of the D.C. Circuit, upheld our argument.
You also said the courts of the United States have never entertained habeas lawsuits filed by enemy forces detained in war zones. If courts are ever to take that radical step, they should do so only with explicit blessing by statute. You stand by that?
Anything that is in that brief, I stand by as the appropriate position of
enough.
the United States government.